I'm talking about this darker side. I'm going to concentrate on, or use as an example, violence, because that's the kind of obvious one, I guess, that distinguishes some of the behaviour you can, or probably shouldn't and can't do on the field from stuff that you could get away with in regular life. So there's some fairly high-profile examples up there at the World Cup final, and Mike Tyson biting ears off and the like. But this obviously also happens in lower-level community sports as well. And one of the things we're going to point to is actually, I'm going to concentrate on an English thing that happened recently, a policy move that happened recently, but I think it has a kind of resonance across the board. Well, not across the board, but in similar jurisdictions such as here. So quasi-criminal behaviour, which in terms of sport and in society in general is that there's an aim to deter and punish it. And the comparison I'm going to draw is the use of the criminal law in society, and then look at how that sometimes is used in sports and what that line is between where it should and shouldn't be. I mean, this comes down to issues of safety, player discipline and misbehaviour, but also the kind of viability and the very shape of sports themselves. And who decides what happens to the perpetrator. So somebody who commits acts of violence which go beyond what a sport would deem acceptable, or alternatively what society in general deems acceptable, what should happen to them? So in-game sanctions like penalties that are in-game, bans from participation, fines through the system of sports governance or through criminal justice, whatever, and at the higher end, obviously implemented by criminal justice system, prison sentences. And again, this comes down to the kind of sharing of power and jurisdiction over the sports field, be that by the police, the courts, or by sports governing bodies, referees, whoever. As I said, I'm looking at the English approach just because a particular policy came in a year and a half ago, but this could, I think, apply equally pretty much to Australian jurisdictions. So I'm going to start from this English Court of Appeal case, which kind of set the ground for what has happened recently in England. It's a case that arose out of a tackle by a guy called Mark Barnes in a low-level Saturday League soccer game, which broke the leg of his opponent. And it was described as reckless, late, unnecessarily high, and he was also heard to say, "Have that," to the victim as he snapped his leg. And he was convicted at the Crown Court, and it then went to appeal to the Court of Appeal, which is the second highest court in England. And the judge there, Lord Woolf, said, the issue to which this appeal raises is an important one. It goes to the heart of the question of when it is appropriate for criminal proceedings to be instituted after an injury is caused to one player by another in the course of a sporting event such as a football match. It is surprising that there is so little authoritative guidance from appellate courts to the legal position in this situation. And he said the explanation for this may be that until recently these prosecutions were rare. However, there is now a steady but fortunately still modest flow of cases of this type coming before the courts, and thus the need for guidance. Now, these don't tend to be, in fact very rarely are, high-level professional players. These tend to be amateur players who kind of go under the radar, I guess, when it comes to media reporting, as was Mark Barnes. And Lord Woolf went on to give, I think this is the key part of his judgment, he said, a criminal prosecution should be reserved for those situations where the conduct is sufficiently grave to be properly categorised as criminal. Now that's a fairly circular, unhelpful definition. So it's criminal if it's criminal. It seems also kind of obvious. I mean, you only want to impose criminal penalties on people who do really egregiously bad things, right? This is not for a late tackle, accidental, even elbow to the face, whatever. You don't want to be punishing people, the police coming onto the field, all that sort of stuff. Now, the criminal law here, I won't go into the kind of niceties of how the criminal law is shaped in this area. It's fairly problematic. It's relatively easily explained quite intuitively by reference to people's consent by taking part. But essentially, when you break that down, it becomes quite problematic. But the view here, I think, is that it's a kind of intuitive one. You know criminality when you see it. And therefore, he's kind of saying, don't bring these cases to the courts if they're not obviously criminal. Now, this brings us to, as the law is kind of complex in this situation and difficult to give, kind of draw firm, bright red lines around it and give kind of clear answers to what would and would not be criminal, you're kind of looking at the police and the prosecutors to not come to the courts with these types of cases. And the police's power, and indeed prosecutors, there's a different system in England than there is across the different jurisdictions in Australia, is pretty absolute in this sort of thing, right? There's a lot of discretion that comes down to people reporting stuff, police bothering to, take it seriously or not, passing it on to prosecutors who then bring a case or not. Okay, there's a lot of discretion at various different points. The police act as a preliminary filter. They control the investigation. They control the decision whether to take this thing forward. And as it says at the top there, their autonomy in some respects is kind of virtually absolute. So this idea of discretion in the system, whether it's the police or the prosecutors, is pretty important. As Sir Hartley Shawcross said about, again, the English system, but this applies equally to Australia, well, to New South Wales. Queensland is not quite my thing, but I would assume it also applies here as well. It has never been the rule in this country, I hope it never will be, that suspected criminal offences must automatically be the subject of prosecution. Indeed, the very first regulations, wherever it appears that the offence or the circumstance of its commission is or are of such a character that a prosecution in respect thereof is required in the public interest. So in other words, you bring prosecutions where it's in the public interest to do so. And here, of course, it may well be far more in the public interest to prosecute someone for punching someone in the streets than it would be in a boxing match, even in a rugby match, even in possibly a game of soccer as well. So we have this kind of idea of only bring cases if it's in the public interest so to do. And there's very few people who work in these kind of systems who would suggest that you should bring every possible technical breach of the criminal law to court. You shouldn't just prosecute anything that might possibly be successful. You should apply this kind of filter that says, should we bring this? Even if we can, should we do it? So Keir Starmer here, talking of his time as the head of prosecutions in England, basically. The adoption of the expediency principle in England and Wales has allowed the enforcement of the rigid structures of state to be flexible enough to allow firm and rigorous prosecutions when necessary, but also to allow the public prosecutor not to prosecute where it is not in the public interest to do so. And he suggests that properly exercised, this discretion delivers justice and is consistent with the rule of law. So these kind of important fundamentals of how the law should be administered, okay? Justice and everyone equal before the law. Now, this is all well and good, but prosecutors and indeed the police work within they are human agencies, and they work within systems that are subject to political, topical pressures, and they are subject to responding to moral panics, to bad behaviour, particularly in England and in the UK, when it comes to overpaid footballers who make headlines very, very easily, and indeed tragic accidents as well. So when people die or are severely injured as a result of something, there is a call to do something. And that inevitably puts pressure on police and on prosecutors to do that. An example of this is the Crime in Sport conference, which took place not very long after that Barnes case came to court as well, in the shadow of an infamous on-field fight between teammates pictured there. Lee Bowyer, the first Newcastle player on the left, and then Kieran Dyer, who just got into a fight in the middle of a Premier League game in 2005, both playing for the same team. And this seemed to kind of inform the discussions that took place at this Crime in Sport conference, and the news reports and the press releases that came out afterwards were all about a crackdown. There'd been things about, I think it was Wayne Rooney spitting, swearing, and all these sorts of things that were seen as a horrible example to children who looked up to these role models. This was, the last straw. And so there was going to be a crackdown. And essentially people came out and said, these people will not get away with things on the field that they wouldn't get away with on the streets. Now that obviously would put boxers in a huge amount of trouble. But then they came up with this draft guidance, and it was much more kind of considered and pragmatic, and it emphasized this idea of context and pluralism, this idea that there is a context to this, okay? There is a heightened game in which physicality is part of it, and also there's a kind of pluralistic response to it as well. There's a regulatory system in place, there's a referee, there's bannings, you can sue. Sending people to prison is probably the kind of last thing we should really be doing. So the guidance that came out of that was a bit more measured and kind of said, take account of the fact this is sports. We can't really treat people on the sports field exactly as we would in other contexts. And that was then replaced, although I'm not really sure what the spur was for this one, but it quotes from Barnes, and it certainly has completely shifted that old guidance out of sight. So in 2013, the end of 2013, the FA, so that's the Football Association, which, as you've heard from other sports governing bodies, is the head of soccer in England, and the Football Association of Wales, so its counterpart in Wales. So, for example, the FA is in charge of the English football team and indeed the Premier League as well. So it's a powerful, rich organisation. They got together with what was called ACPO, the Association of Chief Police Officers, and the CPS, the Crown Prosecution Service, and they came up with this protocol. And this protocol was to govern areas of concurrent jurisdiction, which basically meant crimes that take place where the FA can do something about it. So there's the criminal justice agencies and the FA. So it's a soccer-specific thing. This was then replaced in almost identical terms by an agreement which is still in force now, that was put in place a year and a half ago. Now, the rationale and the purpose of this agreement was a kind of pragmatic one, right? It was to do with clarifying the roles and responsibilities when it came down to these concurrent jurisdictions. So, for example, if we go back to Lee Bowyer and Kieran Dyer here, there is a concurrent jurisdiction here because the FA can do something about it, but so can criminal justice if they want to get involved in a kind of minor scuffle that clearly they wouldn't be bothered to be involved with really, other than telling them to grow up if it was in the street. So, this idea of sharing responsibility and to liaise between them, kind of create channels of communication and to establish a streamlined and consistent approach to these cases. Now, there's a very good reason for this sort of stuff, okay? The criminal law should not be used lightly. And as many people have stated, so here Joel Feinberg, liberal criminal legal philosopher, for every criminal sanction designed to prevent some social evil, there is a range of alternative techniques for achieving it at somewhat less drastic cost. And in relation to consent in the criminal law in particular, if some other state action short of criminalisation, such as advertising, licensing, taxation, civil law remedies, and so on, might be effective in controlling or eradicating the content in question, liberalism, paternalism, moralism are all united in advocating that those alternative means should be pursued first. So if other stuff can do what the criminal law is going to do, don't use the criminal law. It's a coercive, blunt instrument. There are better ways of doing this. And that was something else that, going back to Barnes, that Lord Woolf pointed out as well. So he said, in determining what the approach of the courts should be, the starting point is that most organised sports have their own disciplinary procedures for enforcing their particular rules and standards of conduct. So obviously what the agreement points to, this idea that there are other ways of doing this, and if you liaise between you, you can work out whose responsibility this should be. As a result, he said, the majority of situations, there is not only no need for criminal proceedings, it is undesirable that there should be any criminal proceedings. Further, in addition to a criminal prosecution, there is the possibility of an injured player obtaining damages in a civil action from another player, if that other player caused them injuries through negligence. Now, that's not something I'm touching on today, but it also informs the kind of background, right? There is a pluralistic backdrop to these sorts of things. There are all sorts of ways that transgressive, violent conduct, quasi-criminal conduct can be dealt with. And this is just an illustration, again, that picture of Lee Bowyer and Kieran Dyer, an illustration of how, in this situation, the criminal law is not a very good thing to be using. Now, as a result of that fight in 2005, Kieran Dyer was not seen as the instigator of this, so he kind of got away with nothing, I think. But Lee Bowyer was banned for 7 matches, which is, a fairly big thing. He was also fined £30,000 by the Football Association. He was also fined around £200,000 from his club, about 6 weeks' wages, I think it was, which was the most they could do. And it was kind of the final nail in the coffin of a fairly stop-start international career for England as well. He was sort of untouchable after that. So, what the governing bodies could do and the clubs could do was pretty heavy stuff they could do to him. In contrast, what the criminal law did to him was fairly minor. So he was prosecuted, he was charged with a public order offence, and he pleaded guilty to a slightly lesser public order offence. And he was fined £600, and he was also made to pay £1,000 costs as well. Now, he would have a criminal record, of course, as well, but I'm not sure that bothers Lee Bowyer all that much. He was earning, as you may have worked out then, somewhere around £30,000 a week for a good, well, a decade plus. So he's fairly comfortably well off. Justifying the decision to prosecute, the chief Crown Prosecutor for the area there said, "The criminal law doesn't cease to operate once you cross the touchline of a sports field," which kind of takes us back to that rule of law stuff, right? The idea that everybody should be treated the same. And that is where this, I think, has potential implications for community sport and for not the high-rank, well-paid professional ranks of sport. The overriding principle of this agreement, and I would suggest that probably this agreement just puts into practice something that was already happening. Probably not with the communication channels quite so open, but this is something that would have been happening anyway, according to those principles of it being in the public interest to get involved or not. But anyway, the overriding principle is the requirement of fair and efficient justice, which is carried out expeditiously, proportionately, and in a transparent manner. In this context, justice is to be given a wide meaning, covering both criminal prosecutions and disciplinary proceedings. So all of this is brought in together, right, as deterrence, punishment, measures that can be taken against misbehaving sports people. And it also says, in this agreement, that the respective sentencing powers of the criminal court and the football disciplinary tribunal will influence the decision whether to prosecute. So in other words, when they get together, and however it takes place, and the agencies of criminal justice and the sports governing bodies talk about what can happen in this particular instance, when it comes to someone like Lee Bowyer, they can ban him, they can fine him, and it will have severe repercussions for him, possibly, in terms of his professional playing life. When it comes to, and I was never a high-ranking, high-achieving sports person, but I have played in the sorts of games that Mark Barnes did. If you try and ban somebody in Saturday League football in the UK, what they do is they turn up the next week with a different name. And there's no real way of stopping people from playing. Now, the criminal justice system can do that probably better. It can put in place certain orders. But the FA doesn't have a great deal of control of people as far down the pyramid as Mark Barnes was and where I have played. So there you would have thought that the FA would turn around to the agencies of criminal justice and say, well, there's not much we can do. We can put in place a ban, but you know, it's not going to be that effective compared to what we can do to somebody whose livelihood depends upon this. And therefore, you know, prosecutors should take account of any relevant FA, FAW, the Football Association of Wales sanction which may be imposed or has already been imposed. And they do also go on to say that things like serious breaches, serious acts of criminality, they don't talk about violence, but it's obvious they mainly mean violence. And things that would bring a custodial sentence normally should be brought down the criminal justice route. And they certainly make it very clear that criminal justice is in charge here. It's not up to the FA to tell the police to go away. You know, we're dealing with this. It should be a kind of a negotiated thing, but ultimately the criminal law is in charge. And yet it still seems more likely that lower level players are going to be prosecuted. And that is true anyway. I mean, some of this is just a function of the numbers who are playing. Obviously, there are far more people who play at a low level than there are who represent international teams or play in the Premier League, for example. But nevertheless, the cases that come before the courts are from them. And some cases are where people are very unlucky and they go and stupidly injure somebody on a police team, for example. You know, these things, it's kind of difficult to keep a track on exactly how these things come about because they're not really catalogued according to whether people are playing sports, but rather according to the offences they commit. So, this is not meant to be alarmist. I'm not suggesting the police are going to be storming onto fields all across the country, but it does seem to me to maybe raise questions around equality before the law and whether this is the right way to go. I accept it's a very pragmatic step. It makes sense. You know, this kind of parsimony of approach when it comes to applying the criminal law is clearly a good idea. But it does raise questions around why and what do we punish. And on that, I think sport has probably got it more sussed than the criminal law in general. It's quite difficult to articulate evidence-based positions for lots of what the criminal justice system does, whereas sports governing bodies are much more, kind of, I guess, clear in their objectives. But they have different priorities, that's certainly true. In many cases, sports governing bodies are interested in promoting their sports. They have different objectives to what criminal justice agencies do, and different agendas. And yeah, finally, I just point to the kind of, is that the final one or the 5-minute one? No. Oh, I'm going to finish anyway with just saying that prosecutors, the police as well, really, they are a kind of executive body, and there's not a great deal of kind of transparency in terms of the decisions they make. And so if they do feel these pressures to act in certain ways, there aren't so many kind of checks in there to stop them from behaving in those ways. And if they go in, if that kind of tends towards unfairness, then maybe that's the way it goes. Like I say, I'm not particularly trying to be alarmist. I just would point to the possibility that lower level players would be disadvantaged as opposed to the pros. That's it. Thank you. I've silenced them.
Are you aware of any other sports that the police and the CPS have made this similar agreement with, or is it just football?
I have asked them, and they said they were considering rolling it out to, I can't remember if they said, I think they just said rugby. Right. That could have meant league, union, I'm not sure.
I know there was a case in the Rugby League, the Super League Grand Final a few years ago with Ben Flower.
Right.
Big punch in the first minute, and there was talk about him being criminally charged, but then the discretion was exercised not to, but
yeah,
there's never really any follow-up as to why.
Yeah, but the thing is, when that hits the headlines, it then becomes a sort of an issue, and it must, I mean, the crime in sport is the only kind of hard evidence I've got for this, that was prosecutors getting together, and the message that came out was really kind of hardline, and that was because it was in the wake of, stuff that was all over the headlines in the news.
Ice hockey has had a lot of criminal type activity and successful prosecutions.
Yeah.
Quite a number, haven't they?
Yeah, in Canada, yeah.
And very serious injuries, and so there's something of a lead. The most violent sport on the planet is Canadian ice hockey.
Yeah, well, they're told, aren't they? They have enforcers, and somebody on the team is the enforcer, and they're told to,
And they've clearly gone down the route of saying, well, in the most egregious cases, we will let the criminal law deal with it.
But even then, if some of the Canadian criminal cases, they're pretty lenient in terms of, they talk about, I can't remember what it was now, they talk about accepted levels of play, and they were talking about high school games. And the list of things that they would take into account in the context was pretty heavy stuff. It wasn't just occasional bumping into people. And this was 15 and 16-year-olds. They were saying they would expect this, serious physical contact deliberately.
Yes. So a king hit would be in the serious category if it involved someone who was badly injured.
Mm-hmm.
Can I make a comment rather than a question? The parallel with this, Ben, is that parliaments around the world are now legislating to make match fixing and spot fixing and gambling offences criminal offences. So the police really have no option there. If matters are brought to their attention, they'll need to investigate, and often they're not visible to the viewer. They don't see the king hit on the TV. Whereas what you've been talking about is something slightly different. It's really the police saying we will get involved or we won't get involved.
Yeah.
So it's really a comment that the arm of the criminal law is reaching into sporting events in lots of different ways. What you've just explained, that police say we will get involved, and Parliament saying we're going to make criminal certain behaviour around this event.
Yeah. The politics is fairly evident in that as well. I mean, it's one of the things that governments, I think, like to do, is say it's to criminalise things. I mean, they don't need to in this because this is clearly criminal behaviour anyway. I mean, it doesn't take much of an extension to...
No, that's right. The gambling stuff they are criminalising, yeah. And you know, good policy reasons behind it if you want to stop it and make it a crime.
Yep.
I mean, in case of the Newcastle player, the punishment from the FA was much more severe than the one imposed from the criminal court.
Yep.
But in general, is it somewhere laid down that these disciplinary codes from the sport associations have to meet at least the same standards as the criminal code?
No.
Because you talked about it like several times that there must be equality before the law. And
yeah, well, sports, yeah, in terms of, but I mean, that's a kind of an ideal of law in general. Sports governing bodies, no, they have their own rules when it comes to imposing bans and...
yeah, but when you say you have to prefer them before it comes to criminal cases, then they should at least meet certain standards.
Yeah, but they're obviously they're differential because they couldn't impose. So, for example, if it was me, never mind the money, but the criminal record is pretty destructive for me.
Yeah.
You know, if in lots of people, good luck in getting a job if you've got a violent offence against your name. So that could, I mean, that results in the end of your nursing career, your teaching career, whatever. So that not so problematic for Lee Bowyer, but for lots of other people it is hugely.